Citizen Advocacy Center, and our center is located in Elmhurst, Illinois. We're a nonprofit, nonpartisan legal organization that helps to protect the tools and institutions that promote public participation in the government decision-making process. And we were contacted by...
I'm going to start your time now.
Excuse me?
I'm going to start your time now.
And we were contacted by patrons of the Orland Park Public Library with concerns about the procedures and processes that this library has undertaken in violation of the Open Meetings Act and the Freedom of Information Act, and potentially some First Amendment violations as well. So, cutting through all the drama, the situation is very simple. So I'm going to put aside issues of porn, whether it's legal or illegal, or whether it's child pornography or adults engaging in consensual sex. And I'm not going to talk to you about masturbation. I'm here to talk to you about government bodies, which includes public libraries like this one, that exist for the people, by the people, and of the people. So for one thing, what that means is that people have the right to communicate their viewpoints to this library board during public comment, especially about public business that's relating to this library. The library may restrict the time and the place of those comments through rules and regulations that govern the public comment period, but it emphatically cannot regulate the content of people's speech who come before you during this public comment session. Political speech gets the utmost protection, and I assure you, most of the people who are coming here to speak to you are engaging in political speech. It's that simple. So once again, I can't say this often enough, the library is a government body. As with any other government body, there are constitutional limitations on what you may regulate with respect to free speech. I hope that you learned some of these principles in public school, but I'm going to recount them to you all. So you may regulate the placement of public comment on the agenda. You may regulate the time allotment per speaker. In fact, I encourage it. You may even require people to sign in, but you may not prevent someone from speaking because you don't like what they're saying or because you don't agree with their viewpoint. That is not allowed. You don't get to arbitrarily decide who gets to speak during this period on what matters that please you and to silence people that don't please you. Once people get to this point, please hear out your public and respond proportionately. And the key word here is proportionately. From reports that I hear and other videos I've seen of these board meetings, there's been disproportionate action taken against patrons of this library who are simply utilizing their First Amendment rights during public comment before this board. So it is one thing to refuse to allow someone to speak during public comment, but resorting to police complaints and arrest tactics to silence your critics, that is the lowest form of cowardliness. It is absolutely shameful if that indeed is the kind of behavior that this board is conducting in. So I implore you, just stop it. Instead, listen to the criticism and respond civilly. If your stance is that legal porn may be viewed at the library out of sight of children, then say so. Move on. If you don't have an excuse for refusing to call the police when someone's masturbating in a public forum in front of other people in their view, then apologize and implement new policies. And then move on. So rather than placing so much energy on your detractors, just redirect your energy to where the complaint stems from. Criminal conduct on library property. I would like to emphasize that there is no distinction between an Attorney General's determination letter and a binding opinion with respect to the legal rationale that's put forth in those letters. The only difference between the two is that a binding opinion must be written within 60 days of the PAC's beginning the investigation, and that binding opinion gets deference in the court of law. Does that mean that if someone were to take a case to circuit court and there's a determination letter from the PAC that the judge is going to ignore the determination letter? Maybe. Or they might take a look to see what the legal rationale is, because the PAC does not do sloppy work. It goes through several levels of review at the AG's office before the legal rationale gets to be before you in those determination letters. And I implore you to pay heed. You've received 2 Open Meeting Act violations already. My last statement is, reports are that you are destroying public records, and I want to just warn you that the Local Records Act,
Excuse me, time is.
the Local Records Act prevents you all from destroying public records. Thank you.